Hello and welcome to our show, 60 Seconds with Sergio. I am your host, Sergio Cabanas, attorney at law here in Florida. Thank you for joining me today. Today's question is, Sergio, I need to obtain some kind of restraining order against my spouse to protect me or my children from physical abuse. But how does this process work under Florida law? First, if you believe some type of domestic violence has already taken place or about to take place against you or your children, please seek help as soon as you can. Call the police immediately and seek medical attention if it's necessary. There are also many government agencies and public services that help families through these types of crises. You should consider contacting these agencies for help as soon as possible. The police may take steps with assisting you by arresting the person who committed the domestic violence and pursue criminal charges against that person, including obtaining a no-contact order that prohibits that person from contacting you. But today's question deals more with the process of obtaining a restraining order in cases where domestic violence occurred or if there is a reasonable threat of domestic violence occurring at some point in the future, but the police are not assisting you for whatever reason. Under Florida law, you can actually take steps on your own to obtain a restraining order without the need for police intervention. This process starts with you visiting the office for the county court clerk where this incident took place. They'll talk to you about your case and see if it qualifies as a potential case for a judge to review. Domestic violence is basically any type of unwanted physical attack or stalking. This includes sexual assault, kidnapping, stalking, false imprisonment, or any other criminal act that results in a physical injury. This definition has been expanded to include any reasonable threat of domestic violence. The domestic violence has to be committed by one family member or a household member against another family or household member. This includes spouses, former spouses, or persons related by blood or marriage. This also includes persons currently living together or lived together in the past as family members, or if they had a child in common, regardless of whether they ever married. If it qualifies as a domestic violence case, the clerk of court will help you fill out a special form that will be given to a judge for immediate review. The judge will then make one of three decisions. The first decision the judge may make is that he or she will see if the case legally qualifies for a restraining order. If not, the judge will readily dismiss the case. You have the option of resubmitting your application, perhaps with additional facts or additional evidence if you have any, and the judge would reconsider your petition. The second decision the judge may make is whether or not there's a preliminary finding that domestic violence took place. If so, the judge will issue a temporary restraining order that will be given to the person who had allegedly committed the domestic violence. That person will be known as the respondent in this case. Once the respondent is served with a temporary restraining order, the respondent is prohibited from contacting you in any way. The judge will also set a hearing date, which is when you will return to court to present the evidence that would justify a permanent restraining order. At that hearing, the defendant will also have the opportunity to present evidence that the domestic violence did not occur. If the judge finds in your favor, the judge will impose a permanent restraining order. Of course, if the judge finds that no domestic violence had occurred, the judge will dismiss the case. A third possible result from a judge reviewing your petition is that the judge finds that there was a possibility of domestic violence, but it's not enough to immediately grant a temporary restraining order. Instead, the judge will simply set a hearing date, which is when you'll return to present your evidence of the domestic violence. Again, at that hearing, the respondent will have the opportunity to present evidence that the domestic violence did not occur. If the judge finds in your favor, the judge will impose a permanent restraining order. Of course, again, if the judge finds that no domestic violence occurred, the judge will dismiss the case entirely. I hope this short video provided you some guidance about obtaining a restraining order in domestic violence cases. Remember, this is not a substitute for an actual consultation with an attorney who can review the specific facts of your case. Thank you again for joining me today, and as always, stay informed so you can stay strong.